Welcome to you all. The numbers are still going up, but welcome to everyone that's joined to this session on managing the minefield, that is the storage of gametes and embryos, patient consent to storage, and the posthumous use of gametes and embryos, and disputes about stored material. Unfortunately, one of our scheduled speakers is unable to join us today, so in alternative, we're going to have a discussion about the recent decision in Alabama relating to the status of stored embryos, and then a Q&A after that. So as you can see, I'm joined by my co-host, Christine Allen. More available information is set out on the i3 website, but I can tell you that Christine is a certified embryologist and andrologist who has traveled the world developing and teaching leading-edge vitrification and laboratory automation technologies. She's built IVF clinics across the world and implemented new technologies such as state-of-the-art egg banking, non-invasive PGT-A, and data analytics for success and improvement. Christine is a consultant and an expert in the US FDA, clinical lab improvement amendments, and the American Association of Bioanalysts and ASRM laboratory standards.
Thank you, James, for the introduction. And to reciprocate here, James is a partner at Lawford, Davies & Company, that is a law firm in the US and in Germany. And James specialized in life science and regulation, as well as litigation. Since James has a particular interest in human tissue and cell-based therapies, he advised a large number of clinics, hospitals, universities, research centers that are licensed by the HFEA in Europe. And of course, he has been involved in most of the leading cases relating to IVF, embryo research, genetics, and stem cell research all over the world. That along is a lot, but James is also a very experienced litigator that has been involved in every level of cases in US court and in UK courts. I'm sorry. Much of his work concerns the judicial review of regulatory bodies and cases that are arising as a result of these regulatory actions around the world. We also have with us in here US legal expert Adam Wolf, who is a partner with the American-based law firm Pfeiffer, Wolf, Carr, Kane, Conway, and Wise, which I have to put in here. It's impossible to say Pfeiffer, Wolf, Carr, Kane, Conwell, and Wise without thinking about Suits, the series, right? Because it just flashes in my mind that wall with adding names in there. It's great, which says enough of what these guys have been working with and the amount of cases they handled. Mr. Wolf has argued in an impressive number of legal cases in US Supreme Court and in courts of appeals. He started one of the very first legal practices concerning fertility litigation in US, and his law firm has already represented more than 1,000 people against their fertility clinics and the manufacturers that produces for the fertility clinics here in US. And when we say 1,000, everybody stops to think, right? Wow, 1,000 cases in the recent years, that's a lot. Adam actually has led numerous groundbreaking lawsuits that have resulted in actual significant reforms at the fertility industry, which makes a huge impact. And he is also a recognized litigator as a tier 1 lawyer in US. And Mr. Wolf has been quoted about fertility matters in hundreds of domestics and international newspapers and television. So you probably already saw him out there. So before we start, please remember our certificates are posted in a few days, not immediately. So do not email us. A few days, not immediately. And tonight we're going to place all our questions in the Q&A session and not on the chat. So again, questions not in the chat, questions in the Q&A document. So please let's keep up with that. And I think we'll begin, right, James?
So I'm going to talk about two related issues. I'm going to talk about stored embryos and gametes and some of the difficulties that can arise in relation to the use of material after the death of one partner. And I have been involved in a number of cases in the UK, which have gone to court to try to resolve some of those difficulties. And then I'm going to finish by talking briefly about disputes where couples have separated and the status of stored disputed material. I wanted to start by just looking back in time to the development of regulation in the UK. The UK is often described and referred to as one of the most liberal jurisdictions in the world for IVF and embryo research, and it was certainly one of the first to develop an overarching regulatory framework to govern the creation, storage, and use of embryos and gametes for fertility treatment. But in fact, back in the 80s, when Baroness Mary Warnock was designing this framework that we still have in place today, she and her committee expressed great reservations about the idea of using gametes or embryos after the death of a partner. And they even suggested that this should be actively discouraged and that any child born as a result of treatment after the death of their father should not be able to inherit or succeed to any title. Although that, as a brief aside, shows something of the concerns that they had in terms of inheriting titles. And even after the introduction of regulation in the UK, there were a large, significant number of clinics who adopted ethical policies against allowing patients to have treatment after the death of one of their partners. You see here in the fourth column that 40% of UK clinics disagreed with the idea of the posthumous use of embryos, and 34% with the posthumous use of sperm. But UK law doesn't prohibit, it doesn't ban clinics from treating patients after the death of their partner. What it does do, though, is require that to be valid, the consent that patients provide must specify what is to happen to gametes and embryos in the event that one of the parties who've consented to the creation of an embryo or to the storage of sperm, they must specify what should happen in the event of their death or their mental incapacity. And the legislation also provides a range of other requirements which patients must fulfill in order to give valid consent to storage and use. And the first time that this came to be tested and examined by the courts was in the mid-90s in a case relating to Diane Blood and her husband, Stephen. And it's important to emphasize they were not IVF patients. Stephen Blood developed bacterial meningitis and fell into a coma from which he would not recover. But they had wanted to start a family, and this was not disputed by anyone involved in the case. So she asked a professor at a local IVF clinic to extract sperm from her husband before he died. And the clinic agreed to do this. So the sperm was obtained. And then the question arose, well, what could be done with it? Because of this legal requirement that we have that I just mentioned, that there must be valid consent in place to the storage and use of gametes and embryos. So the clinic contacted the UK regulator, the HFEA, and the HFEA said, no, it can't be used. And in fact, it shouldn't have been taken in the first place. So Diane Blood took her case to court and ultimately to the Court of Appeal. And the Court of Appeal agreed with the HFEA and said it's quite right that it shouldn't have been taken. And in fact, by taking it and storing it, technically, the clinic was committing a criminal offence. But in this case, because this was an unexplored legal and ethical problem, and the first case of its kind, no action should be taken against the clinic. But the court was clear that from now on, the position would be different, because this case clarified and drew a bright line to say, absent valid consent to storage and use, you commit a criminal offence by keeping or using embryos or gametes. This remains the case today, but I wanted to tell you a little bit about some cases where this has been challenged for very legitimate but case-specific reasons. And this young woman is Elizabeth Warren, and she's smiling because she's just been granted a declaration allowing her to use sperm that was in storage from the treatment of her late husband. Her husband was called Warren Brewer, and he developed a very aggressive cancer. He had sperm stored at a clinic in the UK, and the clinic had a policy of asking patients to restrict the period for which they consented to match the availability of their NHS funding. So Warren gave a series of sequential consents to 1 or 2 years at a time. The last of those ran out in 2011, and so the clinic wrote him to say, do you want to extend your storage again? If so, tick the box below. He ticked the box, sent the form back, and the clinic sent him his consent forms to complete. But in between those two events, he died. So the question arose, in the absence of formal HFEA consents, could Beth use his sperm after his death? And initially the HFEA said no, and the case went to court again. And what we did was to bring together as much evidence as we could from all those involved, from Beth, from her friends and family, and from Warren's friends and family, together with all of the evidence that we could find from wishes and views that he's expressed during his lifetime, including the fact that he had consistently and repeatedly consented to the use of his sperm after his death, and that the use of that sperm by Beth. And the judge was satisfied that, taking all of that evidence into account, she was satisfied that if he had been given the opportunity to consent for longer, he would have done so and would have consented to up to 55 years, which was the statutory maximum in the UK. There have also been a number of cases relating to patients who would die imminently. And these cases go to a slightly different type of court in this country where the patient is still alive. And I wanted to tell you about two contrasting cases. The first, from 2018, related to a man who had suffered a catastrophic brain injury from which he would not recover. And the court was satisfied in that case that it was in his best interests, notwithstanding his imminent death, to have sperm retrieved for the use by his wife of that sperm after his death, notwithstanding that he hadn't given explicit consent to such use. And in order to reach that conclusion about what was in his interests, the court looked at all of the facts relating to him, to his relationship with his wife, and quite crucially to this case, the fact that they had already decided to start the pathway to have IVF treatment, but hadn't reached the point of providing their consent to treatment at the time of his brain injury. So taking all of that into account, the court was satisfied that he should be allowed, that she should be allowed to have sperm retrieved and then use it after his death. But the same court took the opposite view in relation to a more recent case at the end of 2022 relating to a young man who was a student in London and had a massive stroke, again, from which he could not recover. He had not expressed any clear wishes during his lifetime, and the application was made by his parents, who wanted to have the sperm extracted to take home to his home country abroad. He did have a girlfriend, but they weren't married, and they certainly weren't having IVF treatment, and she didn't submit any evidence to court. And the court balanced the fact that whilst on the one hand, his parents were saying that they wanted to do what they thought he would have wanted, in the absence of any view being expressed during his lifetime about what he wanted, the court had to attach weight to that as well, and reach a conclusion about how best to balance his rights, and decided overall, taking all of that into account, that it wasn't in his best interests for his parents to be able to arrange for his sperm to be retrieved. The last case I wanted to talk about in terms of a lack of specific consent, so not a lack of all consent, but a lack of specific consent, is another. I'm sorry, I'm only really talking about rather tragic, sad cases this evening, but that's the topic. The young man on the left is Ted Jennings, and that's his beautiful wife Fern on the right. Ted and Fern were having treatment at a clinic in London, and Fern was pregnant with twins when she had a massive complication and died very tragically and very suddenly. They have one embryo left in storage, and although they had consented to treatment, there was no specific consent from Fern allowing that embryo to be used by Ted with a surrogate in the event of her death. We have a rather complex, odd approach with forms in the UK where, although the man can consent to posthumous surrogacy, the woman can't on the same form, and so the couples have to request additional forms to complete to allow that treatment to happen. The court found that although the form did encourage or allow or prompt patients to request additional documentation, they were far from clear, and found that there was no evidence that information had been provided about treatment in the event of her death to Ted and Fern. And Mrs. Justice Tice, a very senior family court judge, found that she was satisfied that if she had been given the opportunity and had known that she needed to do this, she would have done so in order for Ted to be able to use the embryo in the event of her tragic death. Excuse me. Moving on from missing consent to the variation of consent, I'll quickly tell you about two cases that I was involved in, one many years ago and one more recently. The case of Mrs. Yu is also a very sad story about a couple who had treatment at a clinic in Bristol. And you might remember from the table that I put up at the start of my talk, there used to be a number of clinics that had an ethical policy of not allowing posthumous treatment. And this clinic in Bristol was one of those. They'd adopted this policy as a team. And so when Mr. and Mrs. Yu came to the clinic with their consent forms completed at home, the clinic saw that they had ticked the box to allow treatment in the event of the death of Mr. Yu. And the nurse that saw them explained, well, we don't allow that here, so we would be happy to either refer you to a different clinic, or you can change your form and then we'll carry on with the treatment. So they said, fine, we'll just change it. So he crossed out the tick and ticked the box to say no to posthumous treatment. The embryos were then created and stored, and he suffered an enormous catastrophic asthma attack and died very suddenly, and again, unexpectedly. So Mrs. Yu came to the clinic and said, well, I mean, he didn't mean it. Of course, he wanted me to be able to do it. He saw that he ticked the box originally. So the issue before the court was whether the clinic could look behind the amendment, the variation of his consent. And again, a very senior Court of Appeal judge found that unless there was reason to believe that such a consent was either forged or provided under pressure such that it rendered it invalid, the clinic was required to rely on the face of the consent form, however tragic and difficult the consequences of such reliance might be, and that we had to resist the temptation to bend the law to do what was tempting in that way. A happier outcome arose for Samantha Jeffries, who's pictured here, and that's her late husband Clive on the right. Samantha and Clive were having treatment at a clinic in the south of England, and had completed their consent forms at home very carefully. And Clive had initialed all of the amendments that he'd made and variations that he'd made. But there was one change that had not been initialed. They had consented to store for 10 years, but somebody had crossed out the 10 and written in 2. But this was not initialed by Clive. Clive died very suddenly one morning, and Samantha went back to the clinic to ask whether or not she would be able to keep the embryos that they'd had created in storage for longer than the 2 years, the deadline of which was fast approaching, and she wasn't ready to start treatment at that time. So the question arose in court whether the failure to initial, to sign that amendment invalidated the amendment, and the judge found that it did. And so the 10-year period that they'd originally consented to remained the period for which Samantha could keep the embryos in storage and use them in the future. Now, that was the right outcome and a good outcome for Samantha, but you might, if we pause for a moment to take a step back, you might be able to envisage circumstances where a missing signature or initials on a consent form in that way might come as quite a surprise to patients to find that their revision was not effective and that it didn't in fact change their consent. But Samantha was able to keep these embryos in storage and use them at a later date. So in brief summary in relation to posthumous use, they are difficult, complex, and often very tragic cases, and very distressing from those involved, particularly when they're having to deal with very legalistic, complex, distracting problems soon after the death or even before the death of their partner and loved ones. It's not enough to show intent. There must be consent, and it's not always possible to find that. And as we've looked at some cases where there was none at all. But in certain circumstances, it is possible to ask the court in the UK to piece together a sort of mosaic of information which is sufficient to satisfy a judge that patients should be allowed to keep and use gametes and embryos, notwithstanding the lack of explicit consent, and use them after the death of their partner. So with my remaining few minutes, I just wanted to touch on disputes in a different area. And I wanted to do this by focusing on whether or not there are property interests in embryos and gametes. I know that there have been cases in other jurisdictions which have looked at the status of embryos and gametes in terms of property, but in the UK, there haven't been that many. The most notable is a case called Yearworth, which related to a group of men who lost all of their stored sperm samples as a result of a mechanical fault with their cryostorage facility. And they'd stored their sperm prior to chemotherapy and radiotherapy. They initially brought a claim in personal injury, but the court rejected that on the basis that sperm that was outside the body couldn't possibly be considered their person. But the Court of Appeal, very unusually, said, well, that case doesn't work, but why don't you try this case? Judges don't usually do that, but in this case, they wanted to help the men concerned. And the case that they recommended was a claim based on property. And the court found that the regulatory framework that we have in the UK gave the men negative control over what could be done and couldn't be done with their stored material. Only they were able to use it. They generated it for their own use to preserve their fertility options for the future. And the court clearly found that they thought that it was time for the law to approach these things differently, given the advancements in science and technology. And overall found that the men owned their sperm samples as property and therefore could bring a claim based on damage to their property, which was successful. Now, this raises some interesting questions because the law in the UK, certainly, in other respects, doesn't address sperm and certainly not embryos as property. It focuses rather on consent, as we've just seen with the cases I've already talked about, and the use to which embryos and gametes can be put. And that creates a bit of a tension between this property-based approach on the one hand and the consent approach on the other. Another problem is that the case was very much focused on the fact that this material had been stored for treatment. So query what the court would make if it had been stored for different purposes, such as research. And a third dichotomy and tension is about the fact that we don't allow payment or the sale of sperm in the UK. So again, on the one hand, these men were compensated for the loss of their for the loss of their gametes as the owners of those gametes as property, but they wouldn't be allowed to sell them as property. And lastly, if sperm and by extension eggs are capable of being property, well, what about the combination of the two? What about embryos? Well, this has not come up solely as the focus of any litigation in the UK, but it was touched on in a very difficult case about Natalie Evans and Howard Johnson, who are pictured here. Natalie had suspected ovarian cancer, and in the days before egg freezing, it was recommended that she have embryos created before her ovaries were removed, which she did. The couple then split up very acrimoniously, and Howard withdrew his consent to the continued storage of those embryos. And the case went through the UK courts and ultimately went to the European Court of Human Rights. And the nub of the case, it was a very complex case dealing with a lot of different issues, but the nub of the case was really about the fact that the courts had to balance the interests of both parties. And whilst it was clear that Natalie's interests in using these embryos, which were the only prospect of her having her own genetic child, whilst those clearly needed to be taken into account, so did Howard's wish not to be the father of a child that he decided he didn't want. And the court found at every level that it was perfectly appropriate for the UK to allow one partner to withdraw their consent in that way. But in dealing with this, the court did touch on the fact, the question of whether or not Natalie owned the embryos as her property. And in the High Court, Mr. Justice Wall found that there was no property in an embryo. But in contrast to a fetus, both gamete donors have an interest in and rights over embryos. The embryo, however, cannot be considered a person or to have a qualified right to life. And in a little more detail in the Court of Appeal, the court found that in our domestic law, so under UK law, it's been repeatedly held that a fetus prior to the moment of birth does not have independent rights or interests. Thus, even more clearly, can there be no independent rights or interests in stored embryos. Article 2, that's the right to life under the European Convention on Human Rights, protects the right to life, but no convention jurisprudence extends the right to an embryo, much less to one which at the material point of time is non-viable. And I'm going to leave it there because I hope that will lead into the discussion about the Alabama case in a few moments' time. I'm sorry I've slightly overrun, Christine, but that's me done.
And it's okay. I was going to pummel you in the next 2 minutes, but I'll let it slide. James, thank you so much. This was so relevant. I really mean it. We have in here so many questions that are really pertinent to this and really important. It's going to be hard for me to pick just one of them, and I apologize to the audience for this, but James will work on those questions directly with you and he will answer. But there's one question pressing in here that I personally believe it's something that all of us think about sometimes. That is, you're talking about the UA laws, mainly in here and what happens in Europe. But James, do you see a consensus between the way this is taken by law in Europe and specifically in the UK and in other countries? And related to that question, if there is transportation of posthumous material, let's say to UK to US, do you see any points that should be of concern because laws are different, or you see an overall consensus that everybody deals with this more or less in the same way? And as I ask this to James, please, Adam, if you have anything from the US side to add after James' comment, please pitch in.
Yeah, thank you. It is a very good question. I don't have an encyclopedic knowledge of the way that different European countries have approached it, but certainly to the best of my knowledge, most do allow the use of embryos and gametes after the death of one partner. And I realize as you asked the question that I didn't finish the story about Diane Blood, who wasn't allowed to use embryos in her husband's sperm in the UK, but was permitted to take it to Belgium, which had a slightly more liberal approach to posthumous use at that time. I don't know if there'll ever be a complete consensus, but I can imagine that there may well be the opportunity to challenge any certainly European law that prevented a woman from using embryos that had been created after the death of her partner if he had consented to such use. But obviously that's different to a situation where there's a dispute between a couple where both are still alive and don't agree about its future use. Guido will probably know better than me about other European jurisdictions and what their approach is, so perhaps he can touch on that in his talk.
Thank you. Adam, do you see anything from our side?
Sure. I mean, this issue arises all the time in the United States, and it's largely a function of state law. What states are going to allow this and what are not, guided a little bit on what the parties have contracted for in advance. And so for that reason, a lot of clinics in the United States ask their patients in advance what should happen with embryos or other biological material if there is a dissolution of the relationship. If somebody does pass away, and the clinic is, if consistent with state law, supposed to abide by those directives. It is a complicated process, though, and it could change whether you are in California, or it really depends greatly on what state as well as what the patients have consented to in advance.
Thank you. Guido, anything you would like to add from your side?
I think that given the European setting, we should take first into account that there is, I think, no consensus whatsoever on any point in the European community. But moreover, because we want to maintain the European Union, we have a system built in, which is what is called the margin of appreciation. And that allows every country, according to its own cultural and religious values, to determine on personal issues what is going to be allowed. So every country can make its own rules, for instance, on reproduction, but also, and more specifically, on everything concerning posthumous use of gametes or embryos. So I don't think we will ever get to a consensus. I don't think there's any need for a consensus, by the way. But the point is that the fact that one decides something, I mean, one country decides something does not have any implications for the others. It might become a problem as soon as the overwhelming majority of the countries would decide to take the same track. Then for the others, there would be pressure in order to shift in the same direction. But at the moment, I don't think, I would have to look at what the different countries decide, but it's not even half-half. I think there's less countries that accept posthumous use than that do accept posthumous use. So this is clearly also something evolving in time, and we'll see what direction it takes.
Thank you. Well, such a complex question, and thank you all, you guys, for pitching in. I think summarizing the answer, I would say, what a mess. So, and let's leave it like that. Getting the hook in here, I would like to thank you, James, for the great presentation, and I would like to introduce our next speaker. It is an amazing honor to have the leading name in ethics here today, that is Guido Pennings, Emeritus Professor of Ethics and Bioethics at the Ghent University in Belgium. Whoever is here that doesn't know this is huge. And he is also the director of the Bioethics Institute of Ghent. Guido has published extensively on ethical issues related to assisted reproduction and genetics. He is the past coordinator of the Special Interest Group on Ethics and Law for ASHRAE in Europe, and member of the National Advisory Committee in Bioethics in Belgium since 1996. Am I supposed to say 1996? It's been a long time. He's also the chair of the Federal Commission on Medical and Scientific Research on Human Embryos in Vitro and an advisor to the WHO. So again, it's an honor to have you here. Thank you so much. And please, the floor is yours.
Thank you.
We can see it.
Yes, good evening, everyone. Thank you for the introduction and for the invitation. We've just had already quite a detailed presentation of the number of the cases that are showing from time to time. I still believe that this posthumous use is relatively rare, but the case that was mentioned earlier as one of the standard cases, in fact, that started a lot of the discussion all over Europe is the famous Diana Blood case. And I can tell you that I was myself a member of the ethics committee of the clinic that treated this particular case. And I can tell you that we were not particularly happy with the decision by the English court, because all of a sudden they had just transferred their mess into our hands, and it was up to us to decide. It took us about 9 months. It's probably the longest case we had in our history. and not, as I said, not particularly one that we were eager to treat. But I'm going to start with a few of the philosophical problems related to posthumous use. First, there's a whole series of important philosophical questions. I will just give you a few to give you an idea about what we're talking about. First, that's the question of whether a dead person has interests. And if he does, how should we imagine these interests? How do we know them? When do they stop? Can a parental project be continued when a partner dies? This is probably one of the most frequent justifications that is given for posthumous use. Can someone become a parent after death? And I'm now talking about a parent in the real sense of the word, not just being a genetic parent, but is this possible when a person has died? And there's a whole series of other questions that can be raised. I will focus on two issues that are particularly important from a philosophical point of view about posthumous use. The first one is the problem of harm. In other words, how do we define harm? And the second one is the problem of the subject. Now, to make it simple, one of the basic principles in ethics is that an act is judged by its person-affecting consequences. And by that, I mean, if you do good not for the world, but you do good for a person in the world. So you can't do good as such. You cannot increase the total amount of good things or bad things in the world. That is the person-affecting principle. Now, what is the problem? Very simple. When a person dies, the subject is gone. So, and what is most amazing is that the problems we will be tackling are in fact problems that come up in other societal practices. For instance, why do most societies have and respect things such as organ donation forms? Why do they respect wills, deathbed promises? So we see that in our culture, there's a lot of practices, many highly valued practices, that seem to assume that people's wishes, desires, preferences, and so on, after death, should be respected, and that they can be harmed or wronged by not respecting their will. That seems to be the assumption here. As I said, I'm just going to give you a few teasers. This is the first problem I mentioned, the problem of the subject. So as I mentioned, when a person dies, he or she is gone. There's nothing left. There's no person left, no subject left. And still, I would just give you a very simple example. A man has sex with a woman and she becomes pregnant. The man dies before the woman gives birth. Would you say about the man that he was the father? Now, most people even immediately say, yes, of course. Now, yes, of course, is not quite appropriate, I think, for the simple reason that he did not have a child as long as he lived. So how could he have been a father? Now, the possible answer and the most evident answer is that he performed an act during his life that resulted in the birth of the child. Fully agree. But the problem is that in this case, we have a different view on the subject. The subject does not cease to exist when the person's body dies, but when all consequences of his acts have been taken into account. This has been called the biographical subject. We would call him a father because in his life, he has done things that made him a father. But so he didn't end at the moment that his body died, but he, as a biographical subject, is extending into time for all the actions that could be a consequences of what he has done while alive. Now, as you can imagine, this is again a solution that generates its own problems. The second one is the problem of harm. Now, again, we'll use a very simple example to show you how it works. John wants a child. he freezes his sperm with the intention to use the sperm in the future. Very simple. At T1, John freezes sperm. Now, at T2, John's sperm is stolen. So someone has a better use for the sperm than John and steals his sperm. Now, at T3, John finds out about the theft. Very clear, it may be years later, but so at a certain point he finds out that his sperm has been stolen. Now, my question here is, when, so at what moment was John harmed? There are two options. First, you can answer at T2. So that means at the moment that the theft has been committed. Now, if this is your answer, I would challenge you to tell me what exactly is the harm. How was John harmed? Because he doesn't know, there's nothing in his life that has changed up to his own experience. The second possibility is that you say at T3, so when John finds out that his sperm has been stolen. And that's an easy one. There will be plenty of negative emotions. John's life plan is ruined. He will be frustrated about not being able to realize his wish. So it's for T3, it's very easy. You can indicate a lot of possible harm to show that something wrong has been done. Now, think back. Suppose now that John had died before finding out. Would John have been harmed? I think that this is part of the whole problem. Now, I'm going to give you one indication of how this problem can be solved. And this is from an American philosopher, Joel Feinberg, who invented the ante-mortem person. And he's talking about the interest of the person while he or she was still alive. And this solves all the problems that we mentioned, at least to a certain extent. So there is a subject, there is no retroactive causality, which is sometimes in other proposals assumed, and there is a definition of harm, namely the setback of interests. So let us go through this again. What is Feinberg claiming? At T1, person A acquires an interest in X. So X can be anything that person A wants to obtain. At T2, person A dies. And at T3, the interest of person A is defeated. In other words, we find out that something that was necessary for person A to acquire to satisfy his interest is not going to work. Now, Feinberg's solution is the following. He argues that person A has been harmed from the period that he acquired his interest up to the moment of his death. So, let me give you a simple example to illustrate how this works. T1, person A wants his sperm to be destroyed after his death. T2, A dies. T3, the partner uses the sperm to create a child. Now, according to Feinberg, the conclusion is very simple. Person A was harmed from the moment that he wanted his sperm to be destroyed after his death. So because his interest, namely not to reproduce after his death, has been set back by the fact that the sperm has been used by the partner. Now, I give this as one possible explanation, but my conclusion from this philosophy part is very simple. There is no consensus among philosophers about the best answer to these problems, but there is a consensus that there are plenty of problems with every solution. Now, what do we do when we have philosophical problems that we can't solve? Very easy. You just ignore them. And that's what we do. So we do as if the dead person still has an interest, although we cannot show why this is the case. So what is the standard solution? To protect a person's interest, you ask for informed consent. So what you will see, and it's almost universal, that the legislations that allow postmortem reproduction will do so on the condition that the deceased gave explicit permission for the use of his or her material. This is the story that we just heard from James, and that is the case in the UK. By the way, it's also the case in Belgium and in a number of other countries. Now, this means if you apply this kind of approach, that reproductive autonomy, so that normally applies to a living person, survives death. So the person during his life normally has the authority to decide whether or not he's going to reproduce and under which circumstances. Here we do the same thing, but we extend this after the person's death. It can be in a negative way. The deceased person may simply say this material cannot be used, and so that wish outweighs the possible wish of the living partner. Or it can be in a positive way, but then it is obviously less strong, namely that the deceased may allow the partner to use the material, but obviously he or she cannot impose the use of the material when the partner wants to reproduce. Now, this obviously has another attractive point, and that is the fact that this strokes with the more general rule that people can decide what happens to their body within a socially framed setting. Now, neither the wish for a child during life, nor the storage of gametes during one's life is a clear indication that the person accepts the use of his or her gametes after his or her death. So that is frequently with what comes up in court cases. The person wanted a child. That does not mean that he also wanted a child after his death. And the storage is the same thing. You want to preserve the possibility to have a child, but again, not necessarily after you died. And still, when we look at the empirical data that surveyed how people think about this, we find that, in fact, an amazing majority of the people would accept postmortem use. So as you can see, these are just 3 studies. There's a number more in the meantime, but 93% of the men who stored sperm would accept postmortem use by their partner. Same for the couples, and that is a slightly different balance. About 70% of the males and 58% of the females would accept in another study. Nevertheless, if you bring all these studies together, you might argue that there is high support for postmortem use, and that this suggests that a person's autonomy, so that means his or her wish before death, would be respected by allowing the use of the gametes. And this is in fact also the kind of justification that is being used from moving to the explicit informed consent that we saw earlier, and that is in general practiced in a number of other medical interventions, to what is called a presumed consent, or as it is called in the context of organ donation, an opting out system. What does it mean? In fact, it says that the use of genetic material is permitted unless there is a written direction from the deceased against this use. So we assume here that it is acceptable to use the gametes or the embryos after death unless the person clearly opposes this use. Now, one of the most problematic things is obviously how we're going to find out certain things and how we're going to know whether the information that is provided on the wishes, preferences, and so on of the person before he died, is that this information standardly comes from the partner. And that is a problem for the simple reason that the partner is not impartial, and that there may be a conflict of interest in the sense that the partner may have an interest that may lead to a decision that does not respect the deceased wishes. And that is, of course, a problem even in the case of the presumed consent. But at the same time, who else would know what the deceased wanted? The partner is obviously also the person who is best placed to know what the deceased wanted before he died, he or she died. Now, one of the arguments that always comes up is obviously the welfare of the child. Also in this particular context, we saw from James' slides that the original Warner Committee had serious doubts about whether or not this would be good for the children born after such a setting. And there are indeed a number of arguments, both in favor and against. So the arguments against are that the child is orphaned from conception, and not only that, that it is intentionally created knowing that it will be orphaned from conception, which is indeed a strange thing to do. The child will be raised by a single parent, well, at least initially. I have no information on whether or not these surviving partners later start another relationship, but at least at the start it will be a single parent. The child will never know his or her parent in the sense of being able to communicate with the parent. It can be seen as a commemorative child or a symbolic replacement of the deceased. And again, from a psychological point of view, one may question whether this is a good idea. And then finally, there may, of course, be the burden of living up to the expectations, because this is the long-expected child that is going to realize a lot of wishes of the surviving partner. At the same time, there are arguments in favor. It will know, at least in the terms of knowing the identity of both genetic parents. The living partner will most likely, again, I've never seen any studies present a positive picture of the deceased, which of course is also a good thing for the child. And it is, like in other cases, the true that this child can be seen as the expression of the love between his or her parents. So I'm not sure what the final result would be from all these arguments. I don't think there's any clear indication that this is harmful to the children. And so up to that point, I would expect this not to be a major concern, again, until we have further evidence. Now, I have only talked about embryos, about gametes for the moment. I don't think that it changes that much when we talk about embryos. The additional complication for embryos, obviously, is that you cannot undo them. You cannot separate them again afterwards. And thus, you require a joint decision. The easiest solution, obviously, would be to demand a written contract at the start of treatment, stating the destination of the embryos in case of irreconcilable differences and death. And then, of course, you're assumed as a clinic to respect the disposition mentioned in the contract. But as we've just heard from James, all kinds of things may go wrong, leading up to the problem that we do not clearly know the wishes of the deceased. And then I think the balance tips in favor of the surviving partner. In this case, because the surviving partner is a subject with clear interests. And I think that even though there is a possibility that the embryos may be used against the wishes of the deceased, the harm will be limited anyway, and in a way not really comparable or overriding the harm that may be caused to the surviving partner. So I tend to believe that in those circumstances, we should go along with the desires of the surviving partner. Now, to come to my conclusion, I think that explicit written consent, which in many cases is a contract, should be asked whenever material is stored, but also in this particular case, and then obviously also specifically for what should happen when one of the partners or when the person dies. You can add all kinds of additional procedural elements that can prevent some ethical problems. There's a problem of the obligatory waiting time before treatment. There's the issue of non-committal storage, which in fact means that you introduce a two-step process. You can accept to freeze material while at the same time not immediately accepting the use of this material. So you separate these two. And then obviously you can also have counseling in order to be sure that people know what they are doing. I also believe that the presumed consent could be defended in case of emergency or uncertainty. As I mentioned, I don't think we should be very strict in those cases. And I come to almost the same conclusion as James. I think that case-by-case evaluation seems most appropriate given the complex nature of these cases. Thank you.
Thank you so much, Guido. That was great. We've had a huge number of questions, many of which I hope we can come back to later. If I could just ask one which actually touches on a number of the questions that have come up. It's not intended to be purely selfish. To go back to your point at the start about the blood case and the difficulty that you had as a committee dealing with the mess that the UK had passed over to you, would you be able to say a little bit more about why it took 9 months and why it was so complicated? And as I say, it touches on some of the questions that people have asked about scenarios involving a loving couple who clearly intended to have children and then one dies, and what could be done in those circumstances where questions arise about what their intentions were in the absence of consent.
Well, to be honest, one of our main problems was the fact that we didn't like the attitude of the English court. We have made a lot of mistakes, and now we're going to shift the whole thing to someone else. Moreover, by shifting it, you already give a certain expectation to the one you're sending out. So we were, in a way, feeling pressured to agree to the request. The additional problem from our point of view was that in 1995, we did not have a law on posthumous reproduction. So that means we were acting in a void, not entirely, but to a large extent. So we had, in a certain way, to make up our own rules at the moment and on a specific case, which is never such a particularly good idea. So for us, it was a complete surprise. We were not looking forward to it. We had never seen any cases in Belgium, similar cases in Belgium before. And then we had, of course, this whole pressure coming up. So these two elements for one, and third, for us, the case was not clear-cut. So we had, and we didn't do that regularly, but we had interviews, personal sessions with Mrs. Blood in order to find out what was really happening. And the problem, to a large extent, is that we tried to rely on what we expected there to be, namely a clear confirmation that that was what her husband wanted, while in fact there was no such thing. And obviously, when you think about this now, looking back at other cases, it was also impossible to ask, given the fact that this was an emergency and so on. So you can't expect the situation to start fitting into your framework when obviously the whole situation was not suitable for the framework. So for us, it was a constant going back and forth. And I'm not well, I think that we have a law now in Belgium that says explicit consent, and to a certain extent we hide behind it. So it's very simple. New requests, no explicit consent, no. While we probably would have the same kind of thing as you've had in a number of your cases, where there might be no explicit consent, but there might be reason to assume that maybe we should still accept it. But we never get to that step anymore because we block it from stage one. Is that a good thing? Well, it certainly it
saves time.
Time and effort and so on. At the same time, from an ethics point of view, I'm not sure that this is it. So nevertheless, I think we should have rules about this thing, because otherwise we might get messed up with a lot of other contexts and problems and things that are making things even more difficult. And one of your cases is one of those where we can immediately see what the problem would be. For instance, when the recipient would not be the partner. And luckily, in our law, it says it should be the partner, but imagine it would not be there. Then we immediately enter a completely different field. And honestly, I'm not looking forward to those cases.
Well, thank you very much. I'm sure there'll be lots more questions for you later in the Q&A. Moving on to our third section, as I mentioned at the outset, unfortunately, we've had to change the running order a little, but fortunately, we have a great lineup to discuss the very important developments in Alabama relating to the Supreme Court ruling, the status of stored embryos in terms of parenthood, and the implications of that for clinics and outside Alabama as well. And at this point, I'm going to hand back to Christine to introduce and organize the speakers.
Thank you, James, and thank you, Professor Guido. It was amazing. And I guess let's get to the sticky point of our webinar in here, that is what is going on in the US, that is all over the news in a very confusing way, all over the world. And despite all the facts in here, we are confused in the US too. So to try to address this from a factual point of view, handled by one of the best lawyers we have in US at this moment, I would like to invite Adam, the lawyer, Adam Wolf, that is participating here with us, to let us know, Adam, what happened in Alabama? How did this incredible mess started? What are the facts related to this from a court point of view, and the ruling and what followed that, and what happened to the laws in there? Please, Adam, go ahead.
Thank you, Christine, and thanks to all of you for participating, for listening in. I have the pleasure of speaking at lots of conferences, but mostly in the United States with an American audience. And I think we have so much that we can learn from each other around the world in this field. And I just very much welcome the participation, and I welcome a dialogue after this conference for anybody who wants to be in touch and for us to keep talking about this. It's an important issue. I also want to thank Christine, who is not only an amazing professional and somebody who cares deeply, but also a wonderful friend. And so thank you, Christine. There is a lot of misinformation about what has come out of Alabama. But first, I actually want to start with what I see as a positive here, which is that it has sparked a conversation. It sparked a conversation about the importance of IVF work around the world, a conversation about how much people value their embryos, whether that is whether an embryo is considered a person, and we'll get to that as the Alabama Supreme Court ruled, or not. I think it has sort of brought into a heightened sense of focus just how much people value their embryos, and I think for good reason. So, let's talk about what I think are the very unique facts and the unique law that surrounds the Alabama Supreme Court opinion. And first, the facts. How did this actually all happen? So what happened there is that at a fertility clinic in the state of Alabama, it was located within a hospital. And there was one person, I believe he was a patient at the hospital, who just wandered down the hall, opened a door. It happened to have been into the lab of a clinic, opened up the freezer, took out a number of embryos that belonged to different households, and handled them with his hands, and didn't realize just how cold it was going to be in that freezer. Didn't realize that this was different perhaps than a standard, home freezer, and naturally dropped them, right? Didn't have on gloves or any protective gear, and just dropped the embryos, rendered them non-viable. So we have an already somewhat strange factual circumstance where you have this stranger opening up a fertility clinic's laboratory, handling the embryos with his bare hands and dropping them. I've seen a lot of strange things happen in fertility clinics, but never quite that. Now, that somewhat unique factual situation is overlaid against the very unique legal framework that we had and have and has been propelled in the state of Alabama. And so how did we get there? There were a few pillars to the Alabama Supreme Court's ruling. First, Alabama has a very unique statute called the Wrongful Death of a Minor statute, or act. It was passed in 1872, and it allows parents to sue on behalf of their children when their child dies. And so it's not on behalf of the adults, the parents, who are claiming a loss of consortium or some sort of emotional distress. It's actually on behalf of the child, in the name of the child, like that the child has rights. It's a very unique situation. But what happened in Alabama is that this statute, this already unique statute, then didn't define what a child is. And so the Alabama Supreme Court had previously held that an unborn child is a child for purposes of this act, a child for other purposes as well. And the Alabama Supreme Court did that like a number of other states, but not the majority of states in the United States. At the time that Roe v. Wade, which protected a woman's right to choose, was still on the books. And the hope for the people who, for the justices of the Alabama Supreme Court would be at some point the United States Supreme Court would overrule Roe v. Wade. Now you fast forward some number of years, and that's, of course, exactly what happened in the United States. So at the point that Roe v. Wade is overturned, in Alabama, you have not only the statute that allows one to sue on behalf of the child when a child dies, but a child at that point is now defined to include a, quote, unborn child. Then what the Alabama Supreme Court in this case needed to wrestle with, when the parents, the people who were tied to these embryos that were dropped on the ground and brought a claim for the wrongful death of a child, the Alabama Supreme Court needed to wrestle with, what about what it deemed to be an extrauterine child? It's an embryo. Can the embryo be considered a child? Now, the Supreme Court, the Alabama Supreme Court, had already ruled that life begins at conception. So now that's the third pillar of the Alabama Supreme Court's ruling. And what it put together in this final ruling is finally holding that an extrauterine child, an embryo, is still a child under the Wrongful Death Act. And so when you put all of those things together, it allowed the parents in that case to sue the fertility clinic for violating this wrongful death of a minor statute. Now, that ruling received lots of publicity, and for many good reasons. There were lots of people who were shocked that a court of law, pulling back, was saying that embryos are people. And as I said at the beginning, we can all agree that people have significant emotional attachment to their embryos. But, you know, there are no embryos who are speaking on this panel. There are no embryos that are listening in to this presentation. And yet the Alabama Supreme Court ruled that embryos are people. The second reason it received a lot of attention is that one of the justices on the Alabama Supreme Court put in lots of biblical references to justify his conclusion that embryos are people. And that's just not something that is typically done in American courts. And so that too received a lot of attention. But then the third piece was that a number of clinics, in response to the Alabama Supreme Court's opinion, started shutting down or at least ceasing operations. And their concern was that every time you have a more typical issue that arises in a lab, not somebody coming in unauthorized and reaching into the freezer, but somebody who, you know, say somebody who works in the clinic and by accident mishandles or drops somebody's embryos, would that person or that clinic then be on the hook for murder, for homicide, right? Because the embryos that would be dropped in that situation were people. And if those embryos die as a result, clinics started worrying about their, not only their civil legal exposure, but their criminal exposure too. Now, I understand that concern. And so this is all very scary. And this is new ground in the American legal system. And I think the legal systems in all of the countries where you all are listening. But let me try to put your mind at ease for a couple of reasons. The first, and perhaps most important for all of you, is to underscore that this is a rather unique set of circumstances. This is very particular to the state of Alabama that had these four pillars that I went over of its ruling, things that probably would be hard to replicate in any other state in the United States, let alone around the world, which has different views. The second is that as soon as this started happening and clinics were ceasing operations, at least temporarily, the legislature in Alabama created a fix. It effectively immunized fertility clinics from civil liabilities for any injury that occurred to people's embryos. Now, I am not certain that that is a permanent fix. I can imagine a scenario where that is rolled back in whole or in part, but it was pretty clear to the Alabama legislature that it couldn't let stand some ruling that would effectively halt IVF in the state of Alabama. And there became a bipartisan in the United States, Republicans and Democrats, backlash against this ruling, and particularly the implications of that ruling, that fertility clinics could be on the hook for significant civil liability, but also potential criminal liability. And so I think all of that together led to the legislature creating this fix. And I think what this has all come to is an understanding that we can't put fertility clinics in that spot. That fertility clinic, if we're going to consider embryos as human beings, obviously a very controversial statement, and one that is not true in, as of right now, any other state in the United States, that there needs to be some protection for fertility clinics. So one can talk about the merits and the drawbacks of that legislative fix, and I'm happy to do that with you. But for now, know two things. One is that there was that fix because there was such an uproar against this ruling and the effects of that ruling, and an uproar in favor of work in fertility clinics. And the second is that this is a very unique situation to the state of Alabama. It is not true right now in any other state, and I'm unaware of it being true in other countries around the world. So I am happy to answer any questions, but hopefully this elucidates some of the issues in the Alabama Supreme Court ruling, and maybe allays some of your fears about how that can have implications on your own work in or outside of Alabama.
Thank you, Adam. I'm gonna get this hook to start our Q&A section. And I'm gonna start with one myself in here. Sorry, my colleagues in here.
You have prerogative, Christine.
I have to be, right?
Yes.
So Adam, a ruling in Alabama was highly related to personhood because it was establishing personhood. From the legislation that passed, new law in Alabama, did that legislation address personhood at all?
No. The legislation did not say that the Alabama Supreme Court got it wrong in any way. It did not try to say that embryos are not people, or that embryos didn't have, or that embryos weren't a life that had the ability to then bring some sort of legal claim. What that legislation did was say, okay, if the Alabama Supreme Court opinion is right, and we are worried about the effects on clinics, we are going to immunize clinics. We're going to say that there will be no claim that can be brought against clinics other than for people's out-of-pocket expenses, what they paid for any sort of procedure that was, rendered a nullity because of some work that went on in a fertility clinic. So maybe the clinic would be responsible for some thousands of dollars or some low amount like that. But the Alabama Supreme Court, the Alabama legislature in its fix did not roll back anything in that Alabama Supreme Court opinion. And in Alabama today, just like in Alabama 3 weeks ago, an embryo is still considered a person, just with far scarier implications for fertility clinics within the state.
And hooking to that now, have you seen anything from that ruling that forced IVF clinics to stop operating in Alabama at any point?
Well, there was nothing in the ruling that prevented clinics from operating. But clinics did respond to that ruling by voicing significant concerns about whether they would be able to continue to do their work, or if the liability that could be imposed on them for doing that work would just be too great to handle. I think it was also there were real concerns that come out of that, not just for the civil and criminal liability, from the type of action we saw in the Alabama Supreme Court case, but just take one of any number of other examples, which is a clinic in Alabama storing people's embryos, and say that the people whose material was created the embryo moved out of state or died, and there were no instructions on what to do with the embryo. Would the clinic need to hold on to that embryo, or by discarding it, would the clinic be considered, would the clinic have committed murder, right? There are all sorts of implications from this, many of which will be spelled out in the next, years or decades, assuming this ruling stays on the books. But for present purposes, the clinics, the owners of those clinics can breathe a sigh of relief in that they are not going to be responsible for some of the mishaps that occur in the clinic related to the embryos.
Okay, so bringing the point of responsibility and liability in Alabama right now, if any type of negligence or gross negligence or errors in the IVF or mix-up of gametes producing embryos that don't belong to one parent or the other, what are the patient's rights in Alabama right now in cases like this after the new law?
So it's a good question. For a state, the state of Alabama, that purports to care so much about embryos, what the legislature has done is prohibit people from seeking some sort of justice or some sort of accountability if and when those embryos are destroyed without authorization. So on the one hand, you're saying we care so much about embryos. On the other hand, you're saying, well, there is no accountability for people when those embryos are inadvertently destroyed. I do want to parse part of what your question was, though, which is that part of it was what happens if embryos are, and I'm paraphrasing, were destroyed. Fair enough, we reached that. But when you said there, let's say transfer to the wrong person, you can still bring a claim for that because the legislation targets only the mishandling or destruction or injury to the embryos, not other situations like transferring the wrong embryo to a person. That you could still have a claim for that, and there could still be civil justice accountability for that. But your more normal or commonplace situation where embryos are discarded without authorization, that now, at least for the foreseeable future, is immunized from liability in the state of Alabama.
Thank you. So let's open to questions and answers from everyone in here. If Professor Guido, James, everyone could please join us. We have an enormous amount of questions. So James, would you like to pick anyone here to start?
Yeah, so Adam, we've had a large number of very similar questions on a very specific point, which was to ask what happened to the patient who broke into the storage facility and destroyed the embryos. Do you know what the upshot of that was for him?
You know, that's a great question. I actually don't know the answer to that. And, you know, there certainly should be some sort of accountability for that person. And I will say that this is not an entirely unique situation, though. I have seen other instances where people without authorization have entered the laboratories of fertility clinics. The door is not being secured, or somebody opening the door and not ensuring it closes before somebody else comes in, not having keypads on the clinic that restrict access. So I have seen this occur. Surely there should be safeguards against it, and most clinics do have safeguards against it. But I have seen this happen before. The question of what happened to that individual, I don't know. It's a great question. I'm gonna find that out. So for the next talk, I'll be able to answer that. It's a good question.
Well, we have several questions here, so let me see.
There was one question that somebody asked about the first talk, my talk, which I thought was a really great question and not something that I felt I had time to talk about. But they asked whether the military, the armed forces, have policies relating to fertility preservation. And it's interesting from a legal perspective in the UK, because the only exception in law to the requirement that there must be written consent to storage and use was actually introduced because of the terrible number of soldiers coming back from the Middle East with lower limb injuries after standing on landmines. And so under UK law, excuse me, there is a specific exception that allows clinics to store material for patients who have lost the capacity to consent but are likely to recover the capacity, and can then choose when they recover capacity as to whether or not they wish to store. So that is the one exception under UK law. But I'm glad the question was asked, because I think it does concern me that it's an area that may not be highlighted to young men and women going off to fight. And so something that they may well wish to think about before they go and fill in the appropriate forms in countries where that exception might not exist.
You know, I'll say from the United States perspective too, the U.S. Armed Forces have recently entered into contracts with fertility clinics around the country to provide fertility services to service members. And so it was more common about 40 years ago for the U.S. military to have a handful of fertility clinics at its bases, but more recently has been contracting out to fertility clinics around the country.
We have in here more of a comment than a question that I will leave open for you guys. This says that it's important to appreciate that the Alabama Wrongful Death of a Minor Act is a civil statute and not a criminal statute, and that decision has never brought up any criminal status or questions in any way yet. And the question is, can this criminal ruling be applied in any other state? It was not a criminal ruling, correct? There hasn't been any ruling related to criminal anywhere that any of you have known about?
No, I'm not. The premise of that question is correct, that this was a ruling on a civil claim, not a criminal claim. And by that, I mean, it's, ultimately what you're seeking in a civil claim is monetary compensation, whereas on a criminal claim, it's brought from the government, and typically the punishment would be jail time. This was a civil claim, not a criminal claim. And I'm unaware of any criminal cases in the fertility space in the United States other than two sets of examples. One is where people at a fertility clinic intentionally send or sell people's embryos elsewhere against the authorization or consent of the people who own them. And second, those rare instances that we've all seen in the news where a doctor has inserted his own sperm into a patient as part of an IUI without that patient's consent. But those are the only two criminal issues that I have seen in the fertility space in the United States. Everything else is just a civil matter.
Yeah, I would say exactly the same for the UK. There was one, excuse me, criminal prosecution of a rogue embryologist in the UK who transferred water to women rather than their embryos. And over 100 women either had too many or too few embryos in storage as a result. And he went to prison for assault because they hadn't consented to the procedure that was actually performed, and also for fraud, financial irregularities. But that's an exceptional case, and I'm not aware of any other criminal prosecution like that.
Right. And just to put a fine point on that, those things that James and I are talking about are intentional misconduct, intentional acts. There's also a case where, if you've seen or heard the podcast, The Retrievals, where a nurse was taking fentanyl, diverting it for her own use and putting saline back into the fentanyl bottle. Right. That's a criminal matter. But for everything else, all the issues that I run across, this is not intentional misconduct that we see. It could be reckless, it could, but it's never malicious. And so that's just on the civil side.
We've seen here another question that is recurring in different wordings. And before I ask that, that seems that many people are interested in the answer. I am going to point out and highlighting here that we're not talking to lawyers. We're talking to the super lawyers in here. So for all the people that asked this specific question, these are the ones that are answering to you, and it's that reliable. The question is, today, can embryologists be prosecuted criminally for losing an embryo or for a wrongdoing inside the lab? US and UK, what is your take on this?
After you, Adam.
Sure. I have not seen it outside of those couple of intentional misconduct mistakes. If you are just going about your job, even if you make a mistake, so long as you don't purposefully make that mistake, and then so long as you don't try to hide the mistake, through fraudulently, writing something different in paperwork, it's just an honest mistake, right? And the mistake could have real consequences, no doubt, but that's not a criminal act. It's at most a civil act. And, I would say, it's like I tell all of my people who work at my law firm, right? You do your best, and inevitably you're going to make a mistake. And when you make it, you own it, you're honest about it, and you learn from it. And none of that is criminal misconduct.
The UK is slightly unusual in that we have a civil regulatory and licensing framework that governs the operation of clinics. So clinics have to apply for a license from a regulator to be allowed to create, store, use gametes and embryos. But it is backed up by criminal penalties. So you might have noticed in the slide that I put up quoting the Court of Appeal in the Diane Blood case, that the judge who gave that judgment said technically an offence was committed. So technically, by removing and storing sperm from Stephen Blood, the clinic, well, the embryologist, a senior embryologist who did it, did commit a crime. But as the court went on to say, there was no prospect of any prosecution being brought against him in that case. Now, there are a range of circumstances where it is possible to commit technical offences criminal offences under UK law. But as Adam has said in relation to the US, other than intentional cases, nobody has been prosecuted for that. It is used as a way of regulating and reminding clinics of their obligations under the licensing framework. But in order for there to be a prosecution, it would have to go to a separate organization who would have to decide whether or not a prosecution was appropriate and so on. So it hasn't happened, and certainly I very much hope it will not happen or become more common to resort to criminal sanctions to deal with what are really civil regulatory matters. What is the position in Belgium, Guido? Are there criminal sanctions behind the Belgian regulations?
Well, in general, no. But as I mentioned, I know, for instance, that in France this is quite normal. So there you have almost always criminal sanctions that are included in the same law. So if you do something that is against the rule, you might have 3 years in jail, for instance. In Belgium, I don't think there's anything in the law on medically assisted reproduction regarding criminal law. But obviously, we are seeing our first cases now, for instance, about the gynecologists who use their own sperm. And I think they're trying now to get them as a criminal offense, but I'm not even sure that that will be working. So I think that they, in a way, are restrained by the lack of this kind of regulation in the law. But in general, we don't have this in Belgium. It's just not considered an issue that falls under the general idea of providing a framework for how things should be done. No, there's nothing in Belgian law on this.
Thank you, Guido. And we have another line of questions in here from several participants also that talk about this new legislation in Alabama. And given that a problem exists and errors can occur in any place, how do you guys see from a legal and from an ethical point of view to give immunity to IVF clinics and laboratories, preventing patients from seeking any kind of compensation if anything happens at all? How do you guys see this from a legal and ethical point of view? Does it benefit patients, or it makes it worse to make IVF clinics not responsible or liable for any errors that ever happen? Guido, would you like to start from the ethics point of view?
Yes, well, I think that maybe the real reason why there's such a fuss about Alabama may be linked to the fact that the United States is not used to seeing this kind of direct influence of religious and ideological elements into the court decision. But in fact, in Europe, this is the most normal thing you can have. I mean, every legislation has its influences. I mean, we have 2 countries, at least that I know, that are considering embryos as persons. That's Italy and that's Germany. So obviously the implications are completely different. In both countries, we still have IVF, but this kind of rule limits the possibilities of what an IVF center can do. For instance, both had the same ruling about creating a maximum of 3 embryos, and you have to replace them all in principle, because you cannot create an embryo and then destroy it. So, but you see, you can still practice IVF in a number of, it's also interesting to see that in Italy, for instance, 2004, they had this very strict law, clearly inspired by the Catholic Church, who was then, in fact, overruled by the Constitutional Court. So the Constitutional Court, in a series of judgments, has decided that a number of the rules in the Italian law were just violating people's human rights. For instance, replace 3 embryos when you have a high chance of multiple complications is not a good thing to do. You have to replace embryos of which you knew in advance that they had serious genetic diseases. The court overruled all those steps. So it was in fact the reverse. You had a law that was very strict, and then the Constitutional Court decided otherwise. But even in a country like Germany, you still have the famous rule of 3. You can only make 3 embryos, but you also have a number of other things, which are, if you want, technicalities. You freeze the embryos at the 2pn stage, because then they're not embryos, according to the law. So you see, they all have ways of dealing with it. And the let's say the difference from what I know now about the Alabama case is the extremity of what might follow. So, but you can still attribute a very high moral status to an embryo without saying that you cannot practice any IVF or any medically assisted reproduction. But obviously, the further you go, the more limits that will be imposed, and that may have an effect on the kind of treatment you can provide. There's no doubt about it. But whatever way you turn it, also in the other countries, you have similar culturally, religiously inspired limitations in the law. In Europe, this is a very normal thing to do. And that, by the way, explains why we have this famous margin of appreciation. That is believed to be a national thing that should be decided by the national legislation. And of course, if a country would go as far as Alabama would do now, I think that would create a problem anyway. So in its extremity, it seems to be quite rare, but you can still, on this continuum, you can still move in certain directions without immediately having to stop this kind of practice altogether. And by the way, we do not in Europe have the same kind of attitude of suing and getting immediately millions. You probably wouldn't get much at all. So that, of course, changes the whole atmosphere behind it. And as soon as you start to use criminal sanctions, obviously you're again changing the whole scene. But so influence from religious and so on institutions is there. It's there in the legislation, and it's in a way a consequence of the fact that you allow the states to make their own laws about whatever aspect of medical treatment in general and medically assisted reproduction in particular.
Thank you.
That's a really thoughtful response, Guido. I appreciate that. You know, I think one of the things that I hear you saying is that, you know, clinics have moderated their practices or taken certain steps in order to meet where the law is in terms of whether how many embryos you create or whether it's 2PN or otherwise. And, you know, what I suspect will happen in Alabama is that we'll see some further moderation, both in practices and on the legal side of things. I don't think it's tenable to have in place forever this law that effectively immunizes fertility clinics whenever there is the mishandling or an injury to an embryo. I just think there's going to be a public outcry next time there's some big problem at a clinic. The freezer malfunctions, everybody's embryos perish, right? And nobody is going to have the ability to get any kind of compensation under the current law. I think that will then swing the pendulum back a little bit. And there will be restrictions on when and how clinics can be liable or responsible. But it will not be, you know, it will not allow still things like wrongful death actions or criminal prosecutions. I think that will always be off the table, and I understand why.
Yeah, I mean, Guido made a very good point, which is also true of the UK, even though we're no longer part of Europe, or the European Union at least, which is that in the UK as well, it was agreed and recognized in the 80s when the legislation was being drafted that there would never be a consensus about the status of the embryo. So there would always be one side saying it's a human being, it's a child, and others who would say it's a bunch of cells. And so because of that clash between the two polar opposites, it was agreed that we would allow IVF. We would allow embryo research. We even allow the creation of embryos purely for research purposes, but we'd subject it to very strict, tight regulation, oversight, and inspection, and back that up with the sanctions that I've already talked about. And it's because of the clarity or relative clarity of that legislation, which has lasted until today, that what happened in Alabama couldn't happen in the United Kingdom. It's absolutely clear what you're allowed to do with an embryo under a license. It's clear what its status is, and it is a special status. It's not just a bunch of cells. It is regulated and tightly so. And it doesn't mean that there is complete immunity for those working under licenses. They're subject to regulatory action if they are not coming up to scratch and not meeting the standards that are required by the regulator. And they're also subject to civil liability in the event that they're negligent or they breach the contracts that they enter into with patients. And quite a lot of the work that I do is on behalf of clinics sorting out and undoing or trying to unravel those problems that arise when they do. And I don't think complete immunity is ever a really good idea, but you can do things to mitigate against liability and to manage disputes and disagreements when they arise.
Agreed. So as
I think I was about to say something else, which perhaps I will say. The difference as well is that we don't, although there's an underlying ethical, social, and policy foundation under the regulation, it is never quite as explicit in the UK as it is in the judgment of the Supreme Court in Alabama. And seeing biblical quotes and references to cryogenic nurseries, that is what's different. You do occasionally see quotes from judges in judgments, but it's rarely as tangible or explicit as it was in that rather extraordinary judgment.
Thank you, James. So I would like to wrap up in here, everyone. Thank you so much for participation. I feel incredibly lucky and honored to work with professionals like you guys. It's a sincere honor. Thank you so much. And we will move on right now to our chat, our after party podcast, where we're going to discuss this between us a little bit more. Everybody's invited. Again, thank you everyone for the participation, for the excellent views. And I hope all the participants had a good time and learned something in here and are feeling a lot better about what an embryo is and where we stand right now with all this going on. Thank you, the I3 team that made all this possible. And I would like to just personally say thanks to Jax Cohen, Peter Nadja, Marianne Schwartz that is here with us, Thomas Elliott, Fran Fairley, Giles Palmer, of course, that is here with us, and Violetta Sora. Thank you, guys. And for the panelists, I'll see you in a couple minutes in our chat room. You guys are invited, and if you would like to see the podcast, it's going to be available on the website. Thank you, everyone.
And thank you, Christine.
Bye.
Bye.